All right, David, you ready to move on to some Jack Daniels and some very lucky dogs with their dog toys?
Yeah, I find this case fun only because it's about dog toys and Jack Daniels and not because of the substance much at all, which I'm straining to be interested in. It's mildly interesting, but hey, it's about dog toys, Jack Daniels. Let's go.
All right. So to remind everyone, a dog toy company creates a series of dog toys that are, puns on your favorite liquor. So for Jack Daniels, it's Bad Spaniel. And it's like doing number 2 on your Tennessee carpet. And it kind of looks like a Jack Daniels bottle. Jack Daniels sues on trademark infringement. That's the question before the court. 9-0, Kagan writing. I just want to read this one section because I think it was really fun. First of all, the main case at question here of whether they were going to overturn the Rogers case was actually Ginger Rogers. So that's just a fun, famous person in that case. They declined to overturn Rogers and basically just hold that, Jack Daniels has a case here, and they send it back. Reading from the majority opinion, over the decades, the lower courts adopting Rogers have confined it to similar cases in which a trademark is used not to designate a work's source, but solely to perform some other expressive function. So, for example, when the toy maker Mattel sued a band over the song Barbie Girl with the lyrics, "Life in plastic, it's fantastic," and "I'm a blonde bimbo girl in a fantasy world," the Ninth Circuit applied Rogers. That was because, the court reasoned, the band's use of the Barbie name was not as a source identifier. The use did not speak to the song's origin. A consumer would no more think that the song was produced by Mattel than would, upon hearing Janis Joplin croon, "Oh Lord, won't you buy me a Mercedes-Benz," suspect that she and the car maker had entered into a joint venture. And when Louis Vuitton sued because a character in the film The Hangover Part 2 described his luggage as Louis Vuitton, a district court dismissed the complaint under Rogers. All parties agreed that the film was not using the Louis Vuitton mark as its own identifying trademark. When that is so, the court reasoned confusion will usually be unlikely, and the interest in free expression counsels in favor of avoiding standard trademark infringement Lanham Act test. We offer as one last example of that limitation a case with striking resemblance to this one. It too involved dog products, though perfumes rather than toys. Yes, the defendant sold a line of pet perfumes whose names parody elegant brands sold for human consumption. Tommy Hilfiger versus Nature Labs LLC. The product at issue was named Timmy Hole Digger, which Tommy Hilfiger didn't much like. The majority basically ends by saying this: whatever First Amendment rights you may have in calling the brew you make in your bathtub Pepsi are outweighed by the buyer's interest in not being fooled into buying it. Or in less colorful terms, to the extent a trademark is confusing as to a product's source, the law can protect consumers and trademark owners. Wait, sorry, there is one more, just the Kagan chef's kiss line. In this court, VIP, the dog toy maker, says the complaint was a mere form allegation, a matter of rote. But even if we knew what that meant, VIP has said and done more in the same direction. I also, upon reading that, I was like, what? That's not even a matter of rote. That's not how you use rote.
That's so good. Yeah, as soon as we got into the Janis Joplin line, I loved it because it was evocative. I remember that song well. And B, it was a very clear way of explaining what was going on here. This was not the use of a name like Jack Daniels in a context where you're mocking the effective or you're critiquing the effect of bourbon on society, or you're using it as a prop for a larger point that you're making or whatever. No. There was nothing like that going on. This was, they're selling something that a reasonable person would look at and say, oh, this is sort of Jack Daniels branded merchandise. I didn't know they'd branched into dog toys. And so it was, to me, it was not a close case. Glad Kagan wrote on it because she's such a good writer. But I don't have a lot to say about it, Sarah. I'm all out of interesting opinions.
Well, I have one more note, which is that the concurrence was another fun little couple. You know, we've been talking about the Gorsuch-Jackson bromance, except it's not a bromance because she's a woman. But here we have Justice Sotomayor and Alito joining together in a concurrence. And boy, I may like the Gorsuch-Jackson combo for any number of reasons, but Sotomayor and Alito are really capturing my heart with this concurrence, because if you've ever heard me on any political podcast or any of my writing, you know that there is, I think, maybe nothing I hate more in the political context than someone using as evidence for their point a policy poll, an issue poll, where they're like, oh, well, this says that 82% of people like puppies. Oh my God. And I'm not going to go through it all. Don't worry. Just know that I think issue polling is absolutely the dumbest thing ever, unless, with very small exceptions, basically, if you're doing the exact same poll over time, then you can tell me about changes over time, perhaps. But even then, you're going to have to account for generational differences in the understanding of the poll or whatever. But I hate issue polls. So here in this concurrence, Justice Sotomayor with Alito joining are throwing all sorts of shade on polls used as evidence of confusion. So they're asking basically these survey respondents and using it as evidence of like, see ha, there is confusion, or see ha, there isn't confusion. And here's Justice Sotomayor. When an alleged trademark infringement involves a parody, there is a particular risk in giving uncritical or undue weight to surveys. Survey answers may reflect a mistaken belief among some survey respondents that all parodies require permission from the owner of the parodied mark. Some of the answers to the survey in this case illustrate that potential. And she's quoting one of the survey respondents. I'm sure the dog toy company that made this had to get Jack Daniel's permission and legal rights to essentially copy their product in dog toy form. The bottle is mimicked after the Jack Daniel's barbecue sauce, so they would hold the patent. Therefore, you would have to ask permission to use the image. Plaintiffs can point to this misunderstanding of the legal framework as evidence of consumer confusion. Cleverly designed surveys could also prompt such confusion by making consumers think about complex legal questions around permission that would not have arisen organically out of the world. Thank you. That's all. Literally all.